this computer. A box will come up, but you guys have to allow there to be a recording, so you know. Welcome, everyone. I'm Kate Elliott. I'm the Executive Director of the Autism Society of Southern Arizona. Thank you so much for joining us for this Lunch and Learn today. This very, very important topic about making estate plans and planning for the future for your family and your loved ones. And so I'm going to pass it off to our amazing speaker today, Dawn Garcia.
Good afternoon, everyone. Thank you, Kate, and thank you to the Autism Society of Southern Arizona for inviting me to be here today. I'm so grateful that all of you are attending. I've titled this presentation, Things to Consider When Making an Estate Plan. So let's get started. There's me, longer hair, Dawn Garcia. I have been in the legal field now for about 26 years in various capacities. I have worked and am back working again as a legal assistant. I'm a certified legal document preparer and a licensed fiduciary. For those of you who don't know what a licensed fiduciary is, in a professional capacity, I serve in some of the same roles that you may be serving for your loved ones. So guardian, conservator, trustee, special needs trustee, rep payee. So that's what I do for a living. A few of the things I'm going to cover today, I deal with estate planning. A few weeks ago, there was a speaker, John Hilton, who is an attorney, who provided a good overview of estate planning and things to consider. I am not an attorney. You'll notice that wasn't on my bio there. So please don't construe anything here as legal advice. This is coming from a lay person from in the legal field. Please, if you have any questions, feel free to pop them in the chat, and Kate will go ahead and pass that on to me, and I'll answer them as we go and as they come in. I'm going to start off just giving a little bit of information about a last will and testament. I know sometimes setting up a trust is out of reach for some people. They can be very expensive to have prepared. Maybe you don't have the funds to fund it while you're living. And so at the very least, my recommendation is to the last will and testament. The fact is that the state of Arizona does have an estate plan for you. But the other important thing to know is that that may not be what you want to happen. And so if you can, I think it's important to have a say in what you want your estate plan to be. When we talk about trusts, a lot of times in that trust, you will designate who you want to be a trustee. You can also in your will, if you want to set up in the future a trust for a loved one, such as a special needs trust, which we'll talk about in more detail later. You can set that up through a will. So if you're not going to do a trust while you're living, you can set up a last will and testament that specifies that you want to create that trust upon your death. So if you're not creating or funding a trust in your lifetime, be sure to nominate a guardian and conservator in your last will and testament. That would serve as guardian and conservator for your loved one. I would say also to consider naming an alternate person or persons to serve as guardian conservator for your loved one. This is whether your loved one is a minor or if they're already an adult, and there may be a guardianship conservatorship situation in the future. The reason I think it's important for you to name a guardian and conservator in your last will and testament is because the statutes, Arizona revised statutes, establish who has priority for appointment of someone who may need a guardian and conservator. So by you naming someone, by you nominating someone, you are lifting them into the priority for appointment. So something to consider. I had jumped ahead and said you can establish a will, or pardon me, a trust for your loved one in your last will and testament. That can be, again, a special needs trust if it's necessary, or just a testamentary trust. And that can be funded with resources from your estate that you specify. So just to recap, I think it's super important. I recommend having at the very least a last will and testament, that if you have a loved one where there could be a guardian or conservator situation upon your death, that you nominate who you would want that person to be or people to be. By doing so, you're giving those people priority for appointment, and that through your last will and testament, if you don't want to set up a trust while you're alive, you can state a funding source and specify that you want to set up that trust. Do you have any questions there? Nothing. Okay. I'm going to give you a very brief overview of some of the types of trust that are more common in estate planning. One is a living trust. I think that if you've heard any TV commercials or radio ads where they talk about the horrors of probate and how you need to have a trust, this is generally the type of trust they're talking about. A living trust. It's something, trust is a legal document. It's a contract that you create in your lifetime and you fund it in your lifetime. That's the important part. Not only that you create it, but that you fund it so that you move assets into the trust. So otherwise it's just a piece of paper that doesn't really mean anything. Trusts in your lifetime can be either revocable or irrevocable, which means someone with the authority can make changes or completely get rid of the trust. But most revocable become irrevocable upon your death, which means no more changes can be made once the last trustor, the last person who established the trust, dies. If you have a living trust, or if you want to create one, you can include in that the establishment of a special needs trust. And we'll talk about what a special needs trust is. Any questions about a living trust? Feel free to jump in whenever. A testamentary trust is the trust that gets created that you talk about in your last will and testament. A common appearance is, say you have minor children, and if they are not autistic or have another special need that might require a special needs trust, some parents will say, I want to leave this money to my minor child. If they're under the age of 18, then it should be held for them in trust until they're 25 or 52, or depending how controlling you feel like keeping the money, but protected. But this is a testamentary trust. So it's created through your last will and testament. It's funded after your death. So maybe you have a life insurance policy, or you just want to put all of the assets into this trust. Again, you can establish a special needs trust through your last will and testament, and you would name who the trustees are. And you may have heard some more about this in other places, a special needs trust. Special needs trust is set up as a vehicle so that if your loved one is receiving any means tested benefits, what that means is a benefit where they take your loved one's income and assets into consideration, something like all tax, something like Social Security disability. These are things that they look at your loved one's financial situation in order to determine how many or how much they'll receive in terms of benefits. So special needs trust was set up that would limit how these means tested benefits could look at those assets. Basically, if it's used properly, it makes that money, say there's $100,000 in a special needs trust for your loved one, it makes that money virtually invisible if the rules are followed correctly, which means it would not impact their benefit. So special needs trusts are created either by a last will and testament or a living trust. As I said, it has the effect of limiting the funds that can be considered for your loved one by any means tested benefit programs. One of the criteria is that the trustee must be someone other than the beneficiary. So your loved one cannot serve as trustee of their own special needs trust. It's important that there's that separation. Special needs trusts also have limits. The federal government sets limits on what can be paid from the trust without impacting the means tested benefits. Now, I want to be very clear, that doesn't mean that the items that the government says would have an impact, that doesn't mean they cannot be paid by the trust. Like, I think that's an important distinction. But it's whether or not it will have an impact on your loved one's benefits. Here is a fairly comprehensive list of disbursements that are typically requested from a special needs trust. This relates to minors. You'll see on the next slide, we have adult beneficiaries, and the list is even more extensive. These are things that you can pay for out of a special needs trust if you're the trustee, without there being an impact on your loved one's means tested benefits. So if you're paying for prepaid burial or cremation expenses, or you're paying for furniture for your minor child's room, that is not going to reduce their benefits. Now, in terms of adults, there's a few more things that can be paid for, just a few. But it is fairly comprehensive. The thing that you'll notice, or you may notice, are the things that you cannot pay without impacting their benefits. And to me, these are the really vital basic needs. And so it is important to know that out of a special needs trust, that if you pay for these basic needs, that you can impact the benefits that are received. If your loved one is not receiving any means tested benefits, then that does not preclude them from paying. It does not preclude the trustee from paying for these basic needs. So cash can't be given directly to the beneficiary for any purpose. The trust can't pay for food or groceries, rent or mortgage payment, property taxes, utilities. or trash collection without impacting their benefits. Say, for example, you are paying your loved one's rent. If you're paying for that out of the special needs trust and your loved one either is receiving means tested benefits like SSDI or some other sort of benefit, Altex, then their benefit will be reduced by the amount, a proportionate amount, and what you're paying for rent out of the special needs trust. Again, there are certain scenarios where that makes sense. You know, maybe it's a one-time rent payment because there's some need. There is a chance that that may not negatively impact the benefits, but if it's a continuous payment of the rent, then there could be an effect, and that effect may be worth it. It may not. It's going to be on a case by case basis. Is there any questions on that portion?
Will we be able to get a copy of those lists?
Yes, I have provided a copy of this slide presentation to Kate, and she said she can disseminate that out.
Thank you.
I knew it would be way too extensive for, especially in small print, for anybody to read all those and keep track of them. So
I do have another question while I got you on the line. Is it necessary to have a special needs trust reviewed from time to time to make sure it's in sync with current government rules, or, you know, do they pretty much weather the years when they're written, you know, in the past?
I don't know that answer 100%. I believe that it's less likely than say a living trust that you would want to have that revisited. I can absolutely, if you want to leave your info, I can definitely get a response to you 100% about that.
Right. Okay. Thank you. I'll do that. Go ahead.
Thank you. So in addition to special needs trusts, when we're thinking about providing financially for our loved one, some of you may have already heard of this, but the U.S. Congress passed the Achieving a Better Life Act, and we just refer to it as the ABLE Act. This happened in 2014. Arizona signed on to the Ohio ABLE plan in 2018. Ways that an ABLE account can help is it's sort of a hybrid of a 529 plan and a special needs trust. The good thing about it is that the beneficiary and other, whether it's friends, family members, they can fund this ABLE account. That can be a benefit because a beneficiary is not able to contribute to their own special needs trust. This also allows the beneficiary to have access to the funds, which is something that a special needs trust you can't have. You're able to pay some expenses that can't be paid through a special needs trust without potentially impacting the means trusted benefits, like I mentioned. So if you have a special needs trust in connection with an ABLE account, then the ABLE account can pay the rent, the groceries, the utilities, and still protect those means tested benefits. So any funds in the ABLE account up to a certain dollar amount are also invisible to these means tested benefits. So it's kind of like free money in terms of your beneficiary, your loved one being able to have access to these funds and you being able to contribute to it by, like, if you were paying $1,000 a month toward your loved one's rent, on a personal level, that could impact your loved one's means tested benefits. But if you instead are putting that $1,000 into the ABLE account, and then the ABLE account is paying the rent, there's no impact. So there's some definite pros for some people to have even just an ABLE account on its own, but an ABLE account with a special needs trust seems to be a good benefit for some families. Also, several years ago, the Arizona legislature made some tax rules regarding the ABLE accounts. And so some people may receive a tax benefit, not only if you are contributing to fund the account, but sometimes also for the beneficiary. That may be a plus for some people if there's some tax liability, that you could get a reduction in that tax liability. Contribution limits are adjusted annually, and in general, they follow the annual limit for 529 college plans. I think right now this year it's something like $17,000 for 2023. So that's a good chunk of money. Their Arizona Department of Economic Security has a very good website, and they have a video that talks more in depth about the ABLE accounts. It talks about the different ways to access the funds that your beneficiary can access. I didn't include that, but DES, and I think you could just search ABLE accounts, and that would come up for you. Any questions on the ABLE account and how?
I have a question. With the trust accounts, I have to complete a form for IRS every year. Is the ABLE account similar, where they have some sort of reporting annually, during tax time? Do you know?
I don't believe that there is. The only, because it's invested similarly to a 529 plan, I think you'll get statements, so maybe earnings, but I think that goes to the beneficiary. And so I don't think that there's a separate tax reporting other than tax returns.
And then if the beneficiary is deceased, all those funds go back into the ABLE general account. Is that correct?
It goes to the state. So that is definitely, thank you for bringing that up. That's definitely a consideration, especially maybe a reason not to overfund or fund more than you think that your loved one would spend in a year. So maybe you wouldn't want to put the full 17,000 in January. Maybe you would want to split that up over the year so that those funds do not get surrendered to the state. And I think that may have something to do also if there are benefits received through the state. I think that has an impact on it. So for example, if your loved one is receiving All-Tax and there's that payback provision for receiving those benefits, I think that definitely makes the ABLE account go to the state.
Okay.
So getting away from the wills and the trusts for a moment, as anyone, not just because you have a loved one who is autistic, but I really feel in my experience as a fiduciary, that it's very important for all of us, at the very least, to have healthcare and financial powers of attorney. Healthcare power of attorney, you're designating someone of your choosing to make medical decisions on your behalf in the event you're unable to do so. In terms of if you have an autistic loved one, this may protect them from potentially being the person that medical professionals turn to make a difficult medical decision on your behalf. Especially if you have someone in your life that is on the higher functioning end, you may not want them to be the person who has to make those tough medical decisions. So it's important, I think, that you designate someone to make those medical decisions for you. In terms of the financial power of attorney, again, you're designating someone of your choosing to make financial decisions and to pay your bills in the event you're unable to do so. And this could help potentially provide continuity in payment of expenses for your loved one. Say, for example, you are paying the rent, and if you are incapacitated, that person who is your financial power of attorney could make sure that those payments continue while you're living without interruption, hopefully. So I can never hammer this home hard enough. Just speaking from my experience of serving as a fiduciary, I was ended up becoming appointed guardian and conservator for a gentleman who suffered 2 just debilitating strokes within 7 days of each other. And while he had a will, he didn't have powers of attorney. So he did not designate who he wanted to make medical decisions for him. His adult children didn't want to do it. His partner wasn't willing to do it. And so it became a guardian and conservatorship issue. And he got a complete and total stranger, me, to serve. Not to say that I don't, do my very best in those capacities, but it is different than having someone of your choosing. And I'm pretty sure he wouldn't have selected a complete and total stranger to be making medical and financial decisions for him. So again, I can't hammer it home hard enough. It is important to have a will, but sometimes catastrophic things happen and we don't die. And so we have to deal with, what happens if we're still alive, but we can't manage these things for ourselves. And especially if you have someone who's depending on you, I think it's really important. And I also want to mention, not everyone who has a loved one who is autistic is your loved one isn't always completely dependent on you. And so if you do have a loved one who is higher functioning and they are not in a position where a guardianship and conservatorship isn't an option, then I would recommend that if they have the ability to also have them execute a healthcare and financial power of attorney. Guardian and conservatorship is a useful tool for situations that require it. The courts are very reluctant to take away someone's rights and their autonomy to make their own decisions. So if you do have a loved one who can make those decisions for themselves, I strongly recommend that you have them speak with an attorney, have that or it doesn't have to be an attorney, it could be a document preparer, someone who could prepare financial documents and healthcare, financial and healthcare powers of attorney for them. And that would help a lot in situations where maybe your loved one is an adult and things don't come to light until after they're over the age of 18, but maybe it isn't to the point where you need a guardianship and conservatorship. You can really benefit from having that healthcare and financial power of attorney to help them oversee their finances or help make medical decisions in case they are unable to, or even just need a little bit of help. So that's my soapbox on that. I feel like I have a few soapboxes, but that one in particular. I wanted to leave a lot of time for questions, if there weren't any that have been asked so far. I got nothing.
Oh, wait, somebody says, yes, mine is 19. How do I get power of attorney or become legal guardian?
Okay. So again, depending on your loved one's capacity, they may be able to do, an attorney may be able to prepare, or a document prepare healthcare financial power of attorney. If the requirements are met, where a conservatorship or guardianship would be more appropriate, then that is something you have to petition the court for. You'll need to have a report from a doctor, from a medical provider for your family member that states that they are unable to manage whatever portion, if it's finances or that's the conservatorship, or whether it's the guardianship, like making medical decisions or where they should live. If that is more the case, then you need that medical report, and then you can either file on your own, or there's document preparers out there that can help you, or attorneys in the probate, elder law, estate planning realm, who should be able to help you petition the court for that appointment. It's really individual. It is, like I said, the courts take guardianship and conservatorship very seriously. So if those thresholds for needing that help, if there's no other way that you can achieve the same result, then absolutely the court will consider it and determine whether or not their rights should be taken away. But if there is another way, like I said, through a power of attorney, that's a really good option. Did I answer the question for you?
Miriam, if you have anything else to add, you can just go ahead and speak up. Or anybody else. She said, okay, thank you. So I need an attorney.
Well, like I said, not necessarily. There are document preparers that can prepare the documents for you and help you through the process, or you can do it on your own. I do find if it's guardianship and conservatorship, the court is pretty accustomed to working with parents who are representing themselves, and they do try and make it as painless as possible. I've been to some of the hearings where family members have been petitioning the court for appointment, and they really do try and work with the families.
She asked, how do you find a document preparer?
Well, the Arizona Administrative Office of the Courts has a directory that lists all the document preparers in Arizona. Alternatively, Google. A lot of them have a website, and they'll say what type of work that they do, and you just want to make sure that they do either estate planning or guardianship and conservatorship, depending on which way you think is going to be best. Just remember, they can't give you legal advice on which would be best. So sometimes it's worth an investment to either pay for a consult with an attorney, or to the Pima County Bar Association has a program called Lawyer Referral Service. And for, I think it's still $35. I don't think inflation has hit them yet. I think it's still $35. You get a half an hour consultation with an attorney who specializes in whatever the topic you're calling about, whether it's estate planning or guardianship and conservatorship. So you can get some questions answered, and maybe if you need a recommendation on which way would be better.
Do you do that, Don? Would you be able to?
I don't do document preparation anymore. So sorry, answer is
No,
no on
just-
that. If you want to message me, I'll have my contact information on the last slide. I can send you some recommendations for document preparers.
She said, how do I do it myself? So what would you suggest if she wants to embark on that process?
Are we talking about power of attorney or guardianship conservatorship?
Um, Miriam, she had asked about both initially. Miriam, did you have a specific one that you were thinking that you thought was more appropriate for you?
I'm curious about power of attorney
Okay.
processes.
Okay, so the I believe it's either the Arizona Attorney General or it's the Arizona Secretary of State. They have some forms, some power of attorney forms available online. And they would require either your loved one's signature and a witness and a notary, or sometimes it's just a witness, or sometimes just a notary. So you just have to look at the form, and they're just fill in the blank type. You can print them out, fill them out. Now, I would say too, I can add that there's also another power of attorney that if your loved one is able, there's a mental health power of attorney. So if there are any issues that have arisen or may arise, or the medical team thinks it may arise, maybe your loved one can also give someone mental health powers of attorney. And if whichever it was, the Secretary of State or the Attorney General's office, they also have a mental health power of attorney available on their website. Again, just a form you can print out and fill in and just have signed and either notarized or witnessed or both.
So she said, guardian, I guess I need to apply for evaluation for him, and they ask, am I his guardian? Also making medical making appointments. So is that power of attorney? I'm not sure, new to this. I don't know. I had to get it since I've always spoken for my son. So I guess she's asking to be able to make to get the evaluation done. People are asking her if she is his guardian. So what is the process if she wanted to try and do the guardianship by herself?
So would she be willing to tell me a little bit about her loved one's abilities? Like, are they able to understand what their rights are, and that they would be giving power to someone else, or like what's the intellectual level of functioning?
Miriam, if you're able to share it, you can either put it in the chat and I'll read it for you, or you can say it out loud. While she's doing that, somebody else said, thank you for the information. There are social service organizations that help with this process too. Locally, it is SMILE, SMILE, like all caps, an independent living empowerment agency, but I'm sure in bigger cities, there's more helpful agencies.
And where is that organization SMILE out of? Out of Tucson or somewhere else?
Cindy, do we have that in Tucson?
Not that I know of. I'm in Tucson and
Okay.
I've heard of them, but we do have an independent living center, both big cities. I think Flagstaff does too.
Oh, Yuma and Parker, she says.
Oh, okay.
Okay, Miriam said, I'm not sure what level he is. No, I don't think he understands any of the intricacies for the guardianship she was asking about.
Okay. So I think that just based on that little bit of information and not having a medical opinion, I would say that probably that guardianship is the direction in terms of making medical decisions and determining where your loved one should live. Mary, does your loved one have a general practitioner that they see on a regular basis that would be willing to write a report It doesn't necessarily have to be a full-blown neurological evaluation or something like that.
So I have an appointment for intake, and they say bring him to say what he needs because he's an adult, but I've done all that for him. So Miriam, are you saying that he's unable to speak he doesn't know how to answer those questions because you've always taken care of it? He has a primary doctor, but we're from Florida and I can't get his records.
Okay, but living in Tucson now?
Yeah, he doesn't know how to answer or know what they're talking about. Also, when they ask him questions, can't communicate it. But they're living in Tucson now. But
Okay,
his records before were from Florida, and she doesn't have access to them.
got it. Well, I mean, she could just have him sign, if he's physically able to sign a records request and send it to the medical providers and ask them to provide the medical records, like a HIPAA release form to release those, especially if the local doctor would want to see that before. But if there is a local doctor, I mean, I would just suggest, if you go to the Pima County Superior Court website and you look for guardianship forms, they have an excellent forms packet. Included in that is the report for the medical provider to complete. It's about a 5-page document. And if the doctor can observe the things that need to be answered and is willing to complete it, then that may be enough.
What was the website again that you're supposed to go to for that one?
Pima County Superior Court.
I'll type it into the chat for you guys. Good, I'll find an actual link for you. Are there any other questions?
I have a question going back to the testamentary trust.
Mhm.
Let's just say, for instance, you don't have the money to fund a living trust for your life. So in your will, you write this down that you want to create this trust for your loved one,
Mhm.
and my funds will go there, et cetera, et cetera. So how does that work? I mean, you're obviously not alive to do this. So you have to does it go to probate and then they get a lawyer to draw up the testamentary? How does the testamentary trust get created if you're not really here to do it, if you will? Who
Right.
does that process of, post death? How does that work?
The lucky person that you name as your executor or personal representative.
Okay.
They're going to be the
Executor.
person on the hook for making that happen. Now, does it have to go through probate? I'm going to just try and explain it this way. Probate is for either determining heirs or
Yeah.
for getting access, for the personal representative to gain access to assets that still belong to the deceased person. Okay. So
Yes.
if you're going to fund your testamentary trust with a life insurance policy, then you are going to name your estate as the beneficiary. And the estate, then that goes to the estate and that funds the trust. But if you were to name your loved one, then it goes directly to them and it would bypass any establishment of a trust. Do you see the distinction?
Yeah.
Yeah. So and that could impact benefits, obviously, if they
Right, right,
inherit a
right.
$100,000 life insurance policy. So you're going to want to put it toward the estate. And then in that case, yes, it could go through hopefully what would just be like an abbreviated probate, which would put everything into, if you're putting everything into establishing that trust for your loved one, then it would just, the executor or personal representative would marshal all the assets and then move it into the trust once all the bills are paid.
Okay. All right, thanks. I'm not familiar with that, so appreciate it.
Yeah.
Thank you, Dawn. This was incredibly informative. I think my takeaway is that the most important thing any person can do, if I heard you right, is to do a power of attorney for financial and health care. But I think you're also strongly encouraging anyone who's over the age of 18 that's a loved one that has special needs to have one. Do you recommend a child, well, not a child who turns 18 to have one as well if they don't have special needs?
Absolutely. I mean, I think that, yes, you're going to have, like, the way the medical establishment, in my experience, they look at it, they're going to defer to their own sort of hierarchy of who can make medical decisions. The problem is when reality and the way families are come into it. So if you are an 18-year-old and you have an estranged relationship with your parents, where the medical establishment would probably, even though you're 18 and you're an adult, they would probably look to your parents first to ask, if some medical decisions needed to be made, just in their own little hierarchy, if you don't have a spouse. So maybe if you're estranged from your parents, you don't want your parents to make medical decisions for you. So I think anybody who can legally express their wishes should do so. So my answer is yes, but I think there's a lot of 60-year-olds who don't want to face the fact that that may happen and don't want to have powers of attorney. So I'm not sure how well we can convince some 18-year-olds, but I think it's great for anyone to have it because, like I said, you have a choice. And if you have that, all your parents are deceased and you don't have a spouse and, it's going to be that one sibling that you guys don't get along, you may not want them, messing in your finances, or, you may not want them making medical decisions for you.
That's really helpful. Thank you.
Sure.
Okay, so I've got a question. My name is Regan, and I know that a court can appoint a fiduciary, and you're a fiduciary.
Yes.
So can I hire you to be the trustee and gather the assets and put them in the trust once I die, if I designate you as the guardian and conservatory? Is that possible?
Yes. You
Okay.
you can name a fiduciary.
Okay. Thank you.
I mean, don't name me specifically without meeting me, but
Well, I intended
but a licensed fiduciary can serve in that capacity. Yes.
Okay, great. Because it really comes down to who do you trust, right? And who do you want to burden, what family member, even if you've got, some good candidates, who do you want to have do this for you? Yeah,
Yes.
thank you.
And I haven't really expressed this maybe forcefully enough, but name alternates.
Yeah, no, you did. And I appreciate that. Yeah.
For the greatest amount of longevity in your document, name alternates, because not everybody is going to maybe outlive you.
Oh, you did.
So it's good to have some spares around. And especially if you're naming, it's an especially important consideration if you're naming a trustee for like a minor child, and especially if that child you're setting up a special needs trust for, because there is a very good chance that that child is going to outlive your trustee. So you got to have some spares.
Mhm. Okay,
And-
great point. Thank you.
So I'm a little confused. So naming the fiduciary would be if you're in a situation where you didn't have legal guardianship, right? I mean, you haven't already gotten somebody or somebody's on to perform that role. In a guardianship capacity, they would automatically be the fiduciaries, right?
Okay, so
Is there a difference?
no, I'm just trying to think about how to answer your question.
Well, like if, for instance, if I name my niece to take over after
Yes.
I pass on, I have a sibling that we have the trust for. And I'm assuming then that she would take over all of the responsibilities just as I have been doing, including that fiduciary role. Or is there something else I'm missing here?
Okay, so you have guardianship and conservatorship over someone?
Yes.
Okay, and so you're saying your niece would step in. Is she currently like a
No,
co-guardian conservator
I'm
or?
I'm giving an example. I have not done this yet. That's why I'm asking.
Oh, okay.
In the
So,
process of trying to figure this part out for the succession. Mhm.
got it. So there's a couple ways that you can do that. If you're just going to petition, you can add that, say, niece with using your example as a co-guardian now, if they're willing. And so that way, if anything happens to either one of you, then you have the other to fall back on.
Right.
Alternatively, then I would say in your estate plan that you would name your niece as the guardian and conservator, or guardian or conservator for your loved one. And maybe, like I said, maybe some alternates in there.
Mhm.
And then if you're talking about like your estate plan is going to fund a trust, then you would name who you want that trustee to be.
Right.
That's a separate thing.
Okay. All right. Thank you.
You know what? Excellent point, because my husband and I are estate planning for our 18-year-old daughter. And if I'm understanding correctly, we should both be petitioning for guardian and conservator for her instead of just one, both of us.
I mean,
Did I understand correctly? Like
it,
husband,
yes,
wife,
no,
husband,
I
wife.
mean, it's not absolutely necessary, but what it does is it helps with the continuity.
Yeah.
If it's just one of you and something happens to the person serving as guardian and conservator, then you have to go back to court. You have to get somebody, you know, if it's just you, and then something happens to you, and then your husband has to step in, then they have to petition the court to get the husband appointed. So if there's both of you, then you have that backup. Or if you
Yeah.
pick yourself and you know, another child or something like that, if you've got two people serving, then you kind of already have that built-in backup without having to go back to court to ask for permission to have somebody new appointed.
That's excellent advice. Thank you. Okay, thank you.
Well, if you need it, here's my contact information. Like I said, I'm not an attorney. I'm also not doing legal document preparation anymore. But what I am doing is if people are serving in the capacities of guardian or conservator, or even under power of attorney, executor of an estate, I do offer training on how to do it so that, like, if you're a conservator and you have to do annual accountings, just trying to help you keep on track so you don't get crosswise with the court. So if anybody needs any help in that realm, that's how to contact me. Hopefully the person who asked about the special needs trust review periodically left their contact information, so I can find out the answer to that question and I'll respond.
Will do.
Wonderful. Thank you so much, Don. This was so awesome. We really appreciate you sharing with us. And I will be sending out the slides and Don's information and a recording of this video. So and a survey link if you guys would please fill it out for us. For all of this in an email as soon as all of it processes. It takes me time for the computer to download everything. But this afternoon, I'll send it on out. Thank you guys so much for being here. And thank you, Don. I really appreciate it.
Thank you all for having me. Thank you, Kate.
Yeah.
Thank you.
This was very helpful. Thank you.
Oh, I'm glad.